You live in California. You own an AR-15. You want to buy a 30-round magazine for it. But you can't, because California bans magazines that hold more than 10 rounds. If you possess a magazine over 10 rounds, you're committing a crime. And in November 2025, the Ninth Circuit Court of Appeals, sitting en banc with all judges, upheld that ban. The court said large capacity magazines are not protected arms under the Second Amendment. Gun rights groups immediately appealed to the Supreme Court. The petition for certiorari was filed on August 19, 2025. The case number is 25-198. And now we wait. The Supreme Court will decide whether to take the case. If they take it, they could strike down magazine bans nationwide. But if they deny cert, California's ban stands, and other states will rush to copy it. This is the final showdown on magazine capacity limits, and the Supreme Court holds all the cards. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal is the most important magazine ban case in American history. The Supreme Court's decision on whether to even hear this case will determine whether millions of gun owners in California and other states can possess standard capacity magazines. Hit that subscribe button right now, because when the court announces its cert decision, you need to know immediately what it means. Here's what happened and where we are now. California passed a law in 2016 banning magazines that hold more than 10 rounds. The law was challenged immediately in a case called Duncan versus Bonta. The original defendant was Xavier Becerra, but Bonta is now California's Attorney General, so his name is on the case. The district court struck down the ban in 2019. The judge said California couldn't ban magazines that are in common use. Magazines over 10 rounds are standard for most modern firearms. AR-15s typically come with 30-round magazines from the factory. Glock 17s come with 17-round magazines. These aren't exotic, they're common. And under the Supreme Court's decision in Heller, the government can't ban arms in common use. The state appealed to the Ninth Circuit. A 3-judge panel upheld the district court and struck down the ban. That was a huge win for gun rights. But then California asked for en banc review. That means all the active judges on the Ninth Circuit would rehear the case. The Ninth Circuit granted the request. And in November 2025, the en banc court reversed. The court upheld California's magazine ban. The ruling was 11-4. The majority said large capacity magazines are not protected arms. They said magazines are accessories, not firearms. And the government can regulate accessories more heavily. The court distinguished magazines from guns themselves. They said the Second Amendment protects guns, but it doesn't necessarily protect every accessory or component. The dissent was scathing. 4 judges said the majority completely ignored the Supreme Court's decision in Bruin. Bruin said gun regulations must have historical analogs. The majority didn't do that analysis. They just said magazines are different and upheld the ban. The dissent said this is exactly what Bruin was meant to prevent. Lower courts ignoring Supreme Court precedent and inventing new tests to uphold gun control. Gun rights groups filed a petition for writ of certiorari with the Supreme Court on August 19, 2025. A petition for cert is a request asking the Supreme Court to hear the case. The Supreme Court doesn't have to take every case. They choose which ones to hear. The petition argues the Ninth Circuit defied Bruin. The court should take the case to correct that defiance and clarify that magazine bans are unconstitutional. Now the Supreme Court will decide. They could grant cert, which means they'll hear the case, or they could deny cert, which means they won't. If they grant cert, oral arguments would happen in 2026. A decision would come down in June 2027, and that decision would be binding nationwide. Every state with a magazine ban would have to follow it. But if the court denies cert, the Ninth Circuit's decision stands, California's ban is upheld, and gun owners in California are stuck. Other states will see this as a green light to pass their own bans. We're at a critical moment. The court's decision on whether to take this case is just as important as the ruling itself. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down every state with a magazine ban and how Duncan versus Bonta affects them. Subscribe right now so you don't miss it. Now let's talk about the legal arguments in detail, because this case is incredibly important. The district court's original ruling in 2019 was based on Heller. The Supreme Court said in Heller that the Second Amendment protects arms in common use. The district judge found that magazines over 10 rounds are in common use. There are over 100 million of them in circulation. They're standard equipment for modern firearms. Therefore, California can't ban them. Simple. But the Ninth Circuit en banc said that's the wrong test. The majority said common use applies to firearms, not accessories. A magazine is not a firearm. It's a feeding device. So the common use test doesn't apply. Instead, the court applied a different analysis. They looked at whether the ban substantially burdens Second Amendment rights. And they said it doesn't. People can still own guns. They just have to use 10-round magazines. That's not a substantial burden. The restriction is reasonable. The dissent said this is exactly what Bruin prohibits. Bruin eliminated interest balancing tests. Courts can't uphold gun laws just because they think the restrictions are reasonable or the burdens are minimal. Courts have to apply a historical test. Is there a historical tradition of the regulation? If not, it's unconstitutional. The majority didn't do that. They invented a new test to avoid Bruin. That's judicial defiance. Now here's the problem. The Ninth Circuit covers 9 western states plus territories: California, Oregon, Washington, Arizona, Nevada, Idaho, Montana, Alaska, Hawaii. The Duncan decision is binding in all those states. If any of them pass magazine bans, those bans will be upheld under Duncan. And the Ninth Circuit is huge. It has 29 active judges. It's by far the largest circuit. So a Ninth Circuit decision affects more people than any other circuit. That's why this case is so critical. If the Supreme Court doesn't step in, the Ninth Circuit will keep upholding gun control laws by ignoring Bruin, and millions of gun owners in the West will lose their rights. Now, quick legal note. This is educational information, not legal advice. If you live in California and you're thinking about possessing magazines over 10 rounds, don't. The ban is currently in effect. The Ninth Circuit upheld it. Violating the law could result in criminal charges. Wait for the Supreme Court to rule before making decisions. Consult with an attorney. Now, let's talk about what the cert petition argues. The petition says the Ninth Circuit created a circuit split. Other circuits have struck down magazine bans or applied Bruin correctly. The Ninth Circuit is an outlier. When circuits disagree, the Supreme Court should resolve the split. The petition also argues the Ninth Circuit's decision directly conflicts with Bruin. The majority opinion reads like it was written before Bruin and just ignores the Supreme Court's new test. That's unacceptable. Lower courts can't ignore Supreme Court precedent. The court should grant cert to enforce its own rulings, and the petition argues this issue affects millions of people. Magazine bans exist in California, New York, New Jersey, Massachusetts, Connecticut, Hawaii, Maryland, Colorado, Vermont, Washington, and other jurisdictions. If the court takes this case and strikes down the bans, those millions of gun owners get their rights back. Let me give you a real-world example of why this matters. Imagine a guy named Mike. Mike lives in Los Angeles. He owns a Glock 19 for home defense. The Glock 19 was designed to use 15-round magazines. That's the standard. But California law says Mike can only use 10-round magazines. So Mike is limited to 10 rounds in his home defense gun. If an intruder breaks in, Mike has 10 shots. After that, he has to reload. Reloading under stress is difficult. It takes time. It could cost Mike his life. Mike feels like the state has handicapped his ability to defend himself, and he's right. The 10-round limit is arbitrary. There's no evidence that limiting magazines to 10 rounds reduces crime. Criminals don't follow the law. They'll get 30-round magazines illegally. But law-abiding citizens like Mike are stuck with 10. That's the injustice of magazine bans. They only affect the people who follow the rules. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about the timeline for the Supreme Court's decision. The cert petition was filed on August 19th, 2025. California has 30 days to file a response, so the response is due by mid-September 2025. Then the petitioners can file a reply. After that, the case goes to the Supreme Court's conference. The court decides which cases to grant cert at their conferences. Conferences happen regularly throughout the term. The court could decide on Duncan's cert petition as early as October 2025, or they could hold it until later in the term. We're watching for announcements. If the court grants cert, they'll schedule oral arguments. Arguments would likely happen in early 2026. A decision would come down in June 2026. That's the optimistic timeline. But cert could be denied at any time. If the court denies cert, that's it. The case is over. The Ninth Circuit's decision stands, and California's magazine ban is upheld. So the first critical moment is the cert decision. Grant or deny. That tells us everything. Now let's talk about the odds. Will the Supreme Court take this case? I think yes. Here's why. The court has been aggressive about enforcing Second Amendment rights in recent years. Heller, McDonald, Bruin, and Rahimi all expanded gun rights. The court is clearly interested in this area of law. Second, the Ninth Circuit's decision directly conflicts with Bruin. The court doesn't like when lower courts ignore its precedents. They'll take cases to enforce their own rulings. Third, there's a circuit split. Some courts are striking down magazine bans, others are upholding them. The Supreme Court resolves splits. That's one of their main functions. And fourth, this issue affects millions of people. It's not some obscure legal question. It's a major public policy debate. The court knows this is important. So I think they'll grant cert. But I could be wrong. The court denies cert in 95% of cases. They're very selective. So even a strong case like Duncan could be denied. We just have to wait and see. Let me give you another scenario. Imagine a woman named Lisa. Lisa lives in San Francisco. She owns an AR-15. She bought it legally years ago. She also bought 30-round magazines during a brief period when California's ban was blocked. There was a week in 2019 when the district court's ruling was in effect, and the stay hadn't been issued yet. During that week, gun shops in California sold millions of magazines. Lisa bought 5 30-round magazines. She's kept them ever since. Under California law, Lisa is supposed to surrender or destroy those magazines, but the law has been challenged so many times that enforcement has been unclear. Lisa has been holding on to them, hoping the ban would be struck down. Now, after the Ninth Circuit's ruling, she's at risk. If she keeps the magazines, she's violating the law. If the Supreme Court denies cert, she has no choice. She has to get rid of them. Lisa is waiting for the cert decision. If the court takes the case, she'll keep the magazines and hope the court strikes down the ban. If the court denies cert, she'll have to comply with the law. This information could determine whether you can keep your standard capacity magazines or have to surrender them. Subscribe now, because my next video breaks down exactly what California gun owners should do while waiting for the Supreme Court's decision. Hit that subscribe button. Now let's talk about what happens if the Supreme Court grants cert, and here's the case. The court would apply the Bruin test. They'd ask, is there a historical tradition of banning magazines over a certain capacity? And the answer is no. There's no historical tradition of magazine capacity limits. Magazines didn't exist in the 18th century, but even in the late 19th and early 20th centuries, when magazines became common, there were no capacity limits. Those are a modern invention. They started appearing in the 1990s. That's not historical tradition, that's recent policy. So under Bruin, magazine bans should fail. The government would argue that magazines are dangerous and unusual. They'd point to mass shootings. They'd say high-capacity magazines are used in crimes. But the court has already rejected those arguments in other contexts. Bruin says you can't justify a gun law just by pointing to public safety concerns. You need historical tradition. And there isn't one. The court would probably say magazines over 10 rounds are in common use and therefore protected. The ban is unconstitutional. That's my prediction. But the court could also rule more narrowly. They could say California's 10-round limit is unconstitutional, but leave room for some capacity limit, maybe 15 rounds, maybe 20. The court could say there's a point where a magazine becomes so large it's unusual, but 10 rounds is too restrictive. That would be a compromise ruling. Gun rights advocates wouldn't love it, but it would still strike down most magazine bans. Now, let's talk about what happens if the court denies cert. If cert is denied, the Ninth Circuit's decision stands. California's 10-round limit is upheld, and gun owners in California are stuck. Other states will pass similar bans. New York already has a 10-round limit. So does New Jersey, Connecticut, Massachusetts, Hawaii, Maryland, Colorado, Vermont, Washington, and others. If the Supreme Court lets California's ban stand, those states know their bans are safe too. And purple states will consider passing bans. Oregon, Nevada, maybe even Arizona. The anti-gun movement will see this as a green light. Let me give you one more scenario. Imagine a guy named Tom. Tom lives in Texas. Texas doesn't have a magazine ban. Tom can buy 30-round magazines, 100-round drums, whatever he wants. Tom thinks this California case doesn't affect me. Wrong. If the Supreme Court denies cert, the precedent spreads. Anti-gun legislators in Texas will propose a magazine ban. They'll point to California and say the Ninth Circuit upheld it and the Supreme Court let it stand. So it's constitutional. We should do the same. Tom could find himself fighting a magazine ban in Texas because the Supreme Court didn't take the California case. That's how these things work. Precedents from one state or circuit influence other states. So even if you don't live in California, you have a stake in Duncan versus Bonta. This case affects everyone. Now let's talk about the political context. Magazine bans are popular with gun control advocates. They see them as a reasonable restriction that doesn't ban guns outright, just limits capacity. But gun rights advocates see them as arbitrary and ineffective. Criminals don't follow magazine limits. They'll use 30-round magazines regardless of the law. The only people affected are law-abiding citizens who now have a handicap in self-defense situations. And here's the reality. Magazine capacity limits don't reduce crime. Studies on this are mixed at best. Some show a small effect, others show none. And even if you could prove a small reduction in crime, that doesn't make the law constitutional. The Constitution protects rights even when exercising those rights has risks. You can't ban free speech just because some speech is dangerous. You can't ban guns just because some gun uses lead to harm. Same principle applies to magazines. They're protected regardless of the public safety argument. Look, I spend hours every week reading appellate decisions, tracking cert petitions, and predicting which cases the Supreme Court will take, so you know what's at stake. The least you can do is subscribe to make sure you never miss the announcement when the court decides on Duncan. Subscribe right now. And, if you found this helpful, share it with every gun owner in California and every gun owner in states with magazine bans. They need to know their rights are hanging in the balance. Spread the word. Remember, This is educational information based on the Ninth Circuit's decision in Duncan versus Bonta and the pending cert petition. It is not legal advice for your specific situation. California's magazine ban is currently in effect. Violating it is a crime. Do not possess magazines over 10 rounds in California unless and until the Supreme Court strikes down the ban. Always consult with a California firearms attorney before making decisions. Stay informed. Watch for the cert decision and hope the Supreme Court takes this case. Because if they don't, magazine bans will spread, and millions of gun owners will lose access to standard capacity magazines. This is the final showdown, and we're about to find out if the Supreme Court will defend the Second Amendment or let the Ninth Circuit gut it.